Good morning, Mr. Morton and Mr. Waldo. We will call the next case. It is People versus, and you'll correct me if I mispronounce your client's name, Mr. Waldo, Uribe. That's what I'm going with. This is a 15-minute mini oral argument on the application. Mr. Waldo, you may attempt to reserve time for rebuttal. That's not going great for people so far this morning, but I wish you the best of luck, and you may proceed when you're ready.
And good morning, Your Honors. May it please the court. Mike Waldo from the State Appellate Defender Office on behalf of Ernesto Uribe. And I request to reserve 2 minutes of my time, please, for rebuttal. We go to see our doctors when we're sick or we're hurt or we're in pain. And we have an incentive to tell our doctors the truth so that they may treat us and that we may be made well. This is the rationale underlying the medical treatment hearsay exception codified under MRE 8034. But that's not what we have here in this case. 4 years had elapsed since the last alleged assault in Dr. Gurton's exam. The complainant didn't seek Dr. Gurton on her own for any medical diagnosis or any treatment. The complainant didn't report any pain, any symptoms, or any complaints to Dr. Gurton during the exam. She saw Dr. Gurton because she was directed to see Dr. Gurton by the lead detective who was conducting a criminal investigation into her allegations. And as a matter of protocol, the detective referred the complainant to see Dr. Gurton after having conducted a forensic interview. Under these circumstances, this exam was not for purposes of medical treatment or diagnosis. Rather, this exam was in furtherance of the ongoing criminal investigation. The critical inquiry when assessing the admissibility of statements under 8034 is whether the declarant had a self-interested motivation to tell the truth in order to receive medical care. Rather than inquiring into that declarant's self-interested motivation, the trial court here applied the Meebor test, which I submit to this court was the wrong test. Meebor was designed to assess the reliability of statements made by children of tender years to their medical providers. And that's not what we have here, where the complainant was 13 years old at the time of her examination. I think this case, the issues raised in this case are recurring issues in our courts today. I think Meebor continues to be misapplied or inconsistently applied. And what we know from the testimony in this case is that here, there was protocol that the child complainant would be forensically interviewed by the police and then sent to Dr. Gurton or another similar medical provider for a medical evaluation, no doubt with the expectation or the intent that those statements would be admissible at court to bolster the complainant's veracity. We ask that this court reverse and remand, and I look forward to the court's questions at any time.
Thank you, Mr. Waldo. I'm going to start with Justice Bernstein.
Counsel, thank you. I have no questions at this time.
Justice Clement.
No questions.
Justice Kavanaugh.
I just have one question. Assuming that we find that that Dr. Gurton's testimony was prejudicial, why did the curative instruction not? Why wasn't that sufficient to cure the
Your Honor, you're referring, I presume, to his ultimate opinion testimony where he said that he believed she was a victim and there was no doubt in his mind. I think, Your Honor, the trial court dutifully interjected and gave an on-the-spot curative instruction. But I think this is the example where there are times where an instruction isn't enough. You can't unring the bell. And what you had here is this was the ultimate issue for the jury to determine, which was whether the complainant here had been sexually abused. And you had an expert of great magnitude and great esteem and credibility who expressed his opinion in no uncertain terms that he believed her. I think that we're often in life looking to somebody of authority to help us out in these tough cases. This case turned on the jury's assessment of her credibility, and Dr. Gurton told them what he felt about that credibility. And so this is the example where the only remedy was a mistrial, was the only way to ensure that Mr. Uribe received a fair trial.
Would we be, if we agreed with you in that this curative instruction wasn't enough, would we be basically adopting a per se rule that a mistrial is required when testimony such as this is admitted? That no curative, I mean, this instruction I think was arguably more curative than the instructions in some of the other cases that we have dealt with more recently. So if we're saying even this is not enough, is that a per se rule that when this testimony comes in that they need a new trial?
I don't think so, Your Honor. Now, this is a grave example of improper testimony being submitted before the jury. But inevitably, I think this court and the Court of Appeals is always going to have to balance the improper evidence against the properly admitted evidence at trial. And so I could envision a situation where the evidence was overwhelming, but that's not the case here. This isn't perhaps a pure one-on-one credibility contest, because I acknowledge there is that rather minimally probative, I think, propensity evidence in this case. But nevertheless, the jury had to believe that this young lady, this was the issue for them to resolve, whether she was abused and she was telling the truth. So in a case like this, I think mistrial is the only proper remedy.
Okay, thank you.
Justice Welch.
No questions.
Justice Zara.
Thank you. I'd like to follow up on Justice Kavanaugh's questions. As I understood it, your response was this isn't going to result in a per se rule, and in this type of testimony is admitted, that it's going to be a reversal regardless of what the trial court does. Accurate summary of what your response was?
I agree, Your Honor, because the error must always be weighed against the evidence at trial.
So my question is, what more could this trial judge have done by way of a curative instruction that would have given way to the remedy of mistrial? I mean, mistrial is no small thing, and we assume the jurors accept the instructions provided by the court. The court immediately gave a special instruction. The court reminded them about the special instruction at the time the jury was charged. Both the prosecutor and defense counsel in closing referenced in a way that reinforced this notion to the jury. It's very much stronger curative action than was seen in Thorpe or Harbison. So tell me, what more was the judge to do to correct this error? Nothing,
Your Honor. She made an on-the-spot correction and gave an instruction. I acknowledge that, and she dutifully did that.
You are advocating for a per se rule then.
Well, I think it always needs to be weighed against the evidence that was admitted at trial. And I could envision a scenario where evidence was overwhelming, where there were eyewitnesses to the alleged assault, where there was forensic evidence that was introduced, where there were admissions that were introduced. None of that exists in this case. And so I think that the error must always be assessed against the evidence that was admitted.
Okay, thank you.
Justice Viviano.
Yeah, I have one or two questions. Counsel, if we only were to focus on the hearsay evidence, and if we agreed with you that it was improperly admitted, was your client sufficiently prejudiced by that testimony to warrant a new trial? It would appear that it's entirely duplicative of the testimony the victim herself gave at trial.
Yes, Your Honor, I believe he would warrant a new trial, and I don't think it's purely duplicative of what the complainant testified. First, as this court held in Douglas, there is a prejudice to Mr. Uribe in the mere repetition of the complainant's allegations, detailed allegations, through the prism of this very esteemed, very impressive expert, Dr. Gurton. But he didn't only repeat her statements. If you read closely through both the direct and a bit on cross, Dr. Gurton is not only repeating the statements, but he's often qualifying those statements and explaining and answering questions about those statements, about why her explanations in these various issues fit the paradigm of somebody who was sexually assaulted. For example, he kind of defends her, bolsters why her answer why there was no bleeding, and even gets into some opinion testimony about why it mattered that she said, and why it sort of bolstered her credibility, I think, when she explained that allegedly Mr. Uribe had threatened her not to say anything to anybody. And Dr. Gurton states that that's relevant because perpetrators often threaten their complainants or their victims not to report. So he didn't just repeat the statements. He's qualifying and offering opinion and insight about why these opinions fit the paradigm. And then frankly,
some of that at least he's permitted to do, right? Even if he didn't repeat the statements. to give it some context, as long as it's context that only an expert could provide, right?
Right, Your Honor, but if he's not here parroting back the allegations that she made to him, then he's not in a position to be offering those opinions. And furthermore, the issue, the ultimate opinion that he gave, the ultimate vouching when he said, you know, that he believed she was a victim, ultimately said there was no doubt in his mind that she was a victim. I think the harm there, and I realize
you're sort of changing the subject, but along those lines, well, how do you respond to the argument that the trial counsel opened the door by asking the question of whether that he made that diagnosis of sexual abuse in the report?
So I think the first point, I wasn't trying to change the subject, Your Honor, but your point's well taken. I was trying to indicate that harm flows from the harm of letting Dr. Gerton to come in here and repeat back the statements that the complainant made to him.
There is a way of looking at it all holistically, but there's also a way that we might be called upon to look at it piece by piece, right? If we're persuaded that the curative instruction was enough, or that trial counsel opened the door on the diagnosis testimony, then we might be forced just to look, if we agreed with you that it was error to admit the testimony, on the impact of the hearsay testimony. That's why I started there. But let me just move you though to that. How do you respond to the idea that trial counsel opened the door to the diagnosis testimony?
I understand, Your Honor. So a couple points. One, I don't believe he opened the door. He asked a straightforward factual question that Dr. Gerton, in fact, did answer adequately without any undue prejudice to the people. He said something along the lines of, "My report speaks for itself." And he later said, "Well, you're right. I don't have that specific portion of my report." So I think it was a factual question that Dr. Gerton fairly answered without getting into this grave opinion that he submitted unfairly to the jury.
I think the trial counsel was presumably working on this issue about whether the victim was there for treatment or not. Couldn't defense counsel have made that point to the jury by simply asking whether the doctor made any diagnosis in his report? I mean, in other words, by going further and saying and bringing into play this issue whether he diagnosed her as a victim of sexual assault, didn't counsel provoke the response to the doctor, then saying, "Yeah, well, it's not in there, but that's what I think"?
So I acknowledge, Your Honor, that counsel is walking a fine line here. There's no doubt about that. But the rule of curative admissibility is such that we must look at the magnitude of the error and the prejudice from any question by defense counsel and compare that with what came in. The concept of opening the door is one thing, what comes through the door is another. And so in Thorpe, it wasn't opening the door to ask Mr. Cottrell whether children lie. It didn't open the door to Mr. Cottrell's testimony that, yes, they lie 2 to 4% of the time. Here, pointing out to Dr. Gerton that he didn't specifically diagnose her as a victim of sex abuse in his report did not open the door to, well, if you're asking me if I believe her, I do, and she is a victim of sex assault, and there's no doubt in my mind about it.
I mean, I understand the argument, you know, coming close to an issue is a little different than coming right at the issue. But let me just ask you one last question. If we were to conclude that defense counsel opened the door, would that then give rise to an ineffectiveness argument?
I think it could, Your Honor. It's not before this court. It wasn't raised, but perhaps it could.
All right. Thank you, counsel.
Thank you, Your Honor.
Counsel, you want to reserve the 1:30 for your rebuttal?
I will, please, Your Honor. Thank you.
Okay, you may proceed, Mr. Morton.
Thank you, Your Honors. May it please the court, Brent Morton for the Eaton County Prosecutor's Office. Well, as you know, you've submitted to us 3 issues to address. The first issue, you lay out the cases of Garland and Shaw, and between those in the continuum, we need to argue where this should fall, whether Dr. Gerton's testimony of the hearsay medical history was admissible or not. And I suggest to you that the determination should be made based on totality of the circumstances. This was really handled the right way by Judge Cunningham, and this was brought before trial. There was a motion to suppress Dr. Gerton's testimony. She analyzed that. She looked at Meebor factors along with, there's a presumption that because the victim is over 10, that she's going to be honest with her doctor. And as a result of that and findings of fact, she determined that the victim did go to see Dr. Gerton for medical purpose, and the testimony is admissible. And unless the court finds that those findings of facts are clearly erroneous, or that her decision was an abuse of discretion, then that should be left the way it is, because the local courts are better at determining credibility of witnesses and looking at the record. Furthermore, with regard to whether or not this should have come in, I think that the court should look at a broader sense to the lack of motivation for the victim to lie. The defendant was out of the home. There wasn't any sort of vindictiveness by the victim. And what happened here was there was a mental manifestation that resulted from the abuse that came up years later. That caused the disclosure, that caused the referral to an expert in sexual abuse for children. That resulted in her seeing Dr. Gerton, being tested for sexually transmitted diseases, receiving an exam in which there was a physical finding, in which there was a stretching marks on the anus, and I'll touch back on that, on the significance of that. And she, in conjunction with that, she was also receiving psychological treatment. So this was for a medical purpose, and it was admissible. With regard to the second issue, as some of the justices have already discussed, this was invited error. Again, Judge Cunningham did this right. She ruled that Dr. Gerton could testify, but could not give his diagnosis, could not give his ultimate opinion. Now, that was 2 years before this court decided Thorpe and Harbison, but she made the right ruling. And what happened? Well, Mr. Pollack, for strategy, attacked Mr. Gerton on his diagnosis, and not just one or two questions, multiple times. He went at him because he wanted to embarrass him and say that there's no diagnosis in the report. That's fine, but that's invited error. And then in response to that, the judge allowed the testimony to go through, and then got agreement from both parties to give a curative instruction the next morning, and gave a very strong instruction, a very, very strong instruction. And there's not been any suggestion by Mr. Uribe that any of the jurors failed to follow that instruction. I think that is a significant point that we haven't touched on, is that if there was some sort of affidavit, or there's some sort of evidence from a juror who said, well, we discussed that, we decided we were going to throw it out anyway, that's might give some teeth to Mr. Uribe's argument. But the reality is there's nothing to suggest that this instruction wasn't followed. And it was a very, very strong instruction saying the testimony struck and you cannot consider that decision. So there really is, there's no error here because it was cured by Judge Cunningham. And finally, with regard to harmless error, this was not a mere credibility contest between the victim and the defendant. We had the testimony of the victim's own daughter, who was sexually abused by him, and her testimony of that assault. That testimony was challenged before trial. We came all the way up here, and this court said, yes, that testimony is relevant and should be admitted. Furthermore, there was a physical finding during the examination by Dr. Gerton of stretch marks on the anus. There was testimony that could have been caused by constipation or sexual abuse. And Dr. Lugenball, who was the treating physician for the victim, also testified that he'd never treated her for constipation. So that is circumstantial evidence to support and bolster the credibility of the victim in this case. Also, there was a misdiagnosis of ADHD, that Dr. Lugenball had diagnosed her during the time of the abuse with ADHD. Following cessation of the abuse, those symptoms went away. And both the defendant's experts and our expert, Dr. Henry was ours, Dr. Hobbs was the defendant's, testified that often ADHD or sexual abuse, is misdiagnosed as ADHD. So if there is any error here, it's harmless error. Thank you.
Thank you, Mr. Morton. Justice Bernstein.
Hey, counsel, I hear what you're saying and I appreciate the argument. I guess I'm just going to ask it just in a different way. But it seems like this is the kind of thing that's really, once the jury hears it, once it's out there, even with an instruction, I mean, just from a common sense perspective, it does appear that it's hard to come back from that, is it not?
Well, I mean, I disagree. I think that the judge did everything right. And I think I touched on this, but if there was a showing by the defense that that instruction was ignored, that's one thing, but the jurors are expected and assumed to follow their instruction. And if we're going to start making these bright line per se rules where there's an automatic mistrial all the same time, we can get rid of the mistrial rules. I'm sorry.
Counsel, thank you. I think you've answered it quite well. Thank you.
Thank you.
Justice Clement,
Questions, thank you.
Justice Kavanaugh.
I just wanted to follow up on that and what you said about that there needs to be a showing by defense counsel that the instruction was ignored. Do you have, can you cite to me authority of where we have held that? I mean, whether in this context or somewhere else, that in looking at the effect of a curative instruction, that a defendant needs something, affidavit from a juror or something like that. How are we supposed to, or are there other examples where we have required that?
Your Honor, I have none. That's my argument this morning. And it's based on the court's prior standing, and I can't cite the case. I apologize, but jurors are assumed to follow their instruction. So if they're assumed to follow the instruction, then that would be a presumption that they followed the instruction, unless there's some evidence to the contrary. But no, I don't have case law. That's my argument, that I guess I'm asking the court to say, well, look, if we don't have any information that suggests the instruction wasn't followed, then that presumption or the assumption that it was followed should be respected.
Okay, because obviously we have held that even with a curative instruction, sometimes it's not sufficient, right? Without proof of that.
Yes.
Okay, thank you.
But I guess I'll jump in real quick. This was reviewed before trial by a trial judge, and Dr. Girton testified and a determination was made. And so I would ask the court to have some respect, because that was done pre-trial and that was determined beforehand, that what the rules of the game would be, to make sure that you know, because that wasn't followed, the instruction should control. Thank you.
Okay, thank you.
Justice Welch.
Thank you. I'm likewise following up on this curative instruction issue. I am admittedly struggling a bit. I'm wondering if you can think of an example where, I mean, I know your standpoint is that jurors are presumed to follow the instructions. Of course, I understand that. But obviously this court has found that sometimes that's not enough, that, you know, we can't unring the bell, so to speak. So what I'm wondering is, are there examples where a curative instruction isn't enough? Or is it always in a case like this that the jury is presumed to have followed the instructions?
Well, I apologize. I don't have case law regarding when it isn't or isn't, but I think that the things you need to look at are whether or not the instruction was agreed to by the parties. In this case, it was. The judge didn't just stop the proceedings and make a statement off the cuff. She had the parties discuss it and make a determination what the instruction should be, and it was given the next morning. Furthermore, the wording of this instruction is incredibly strong. So if you had a weak instruction, I think that you'd be in a different situation. But I think that those are the two factors that are unique here. There was an objection by the defense of this instruction, and the strength of the instruction warrants its respect. In the converse, if there was an objection and the court said, well, I'm going to give the instruction I want to give anyway, then I'd be more critical of that. Or if it was a weak instruction saying you can do what you want, that would not be, this court should not respect that. But because of the uniqueness and strength of this instruction, I think you should assume that the jury followed it.
Thank you.
Justice Zara.
Thank you. I was a bit confused by your response to Justice Kavanaugh. The very last response you gave. You made reference to some pretrial procedures that took place, and because of that, we should find the curative instruction sufficient. Is that what you indicated?
I apologize. I mixed the two issues together in that response. I do think that the court needs to be respectful of the actions of this judge, and this judge was very mindful to make sure that there was a pretrial hearing regarding whether or not the testimony should come in. And then in response to that, she gave a very strong instruction. But yeah, I mixed the two issues together, and I apologize for that.
Okay, thank you very much.
Justice Viviano?
No questions. Thank you, counsel.
You have 3.5 minutes left, counsel. You may use it as you wish.
I know the court's behind, so I know that you all work very hard to read everything. We have made a lot of arguments about the facts, and I'm just going to rest at this point. Thank you.
Thank you very much. Mr. Waldo, you have 1.5 minutes. Thank
you, Your Honor. Just to be clear factually, the suggestion that the complainant here was misdiagnosed with ADHD is pure conjecture. There was nothing to suggest that diagnosis was wrong. In fact, I believe the record supports that she was meeting with her primary provider, Dr. Luganbill, well after the time frame within which she alleges these allegations occurred, and was still being treated for ADHD with medications changing and things of that nature. Further, regarding the finding that Dr. Gurton did describe having seen in the complainant's anus during his exam, I disagree that was either one of two causes, sex assault or constipation. I think Dr. Gurton was quite clear in his testimony, both pre-trial and at trial, that this is seen often in young people or adults, and that it could occur naturally simply from using the restroom. There was no either or cause. Finally, counsel said at the beginning of his argument that she was specifically there to see Dr. Gurton to be treated for sexually transmitted infection. That's not why she was there. She was very clearly had undergone a forensic interview by the lead detective in the case, and that detective referred her to Dr. Gurton as a matter of protocol. 30 days had elapsed since her allegation and Dr. Gurton's exam. If there was a well-founded concern, perhaps, to be treated for any sort of infection, that could have been done any time prior to Dr. Gurton. That was not the purpose of this exam. One final point I wish to make, Your Honor, and I'll try to be quick. There was some discussion by defense counsel in his closing, I believe, that it would have made more sense from a medical treatment perspective to send the complainant to see Dr. Luganbill, who is a pediatrician, her primary care provider, and somebody whom she has seen and only seen her entire life. And the prosecutor responds to that argument in rebuttal and says she didn't go to Dr. Luganbill, rather she went to Dr. Gurton because Dr. Luganbill could have been biased. She needed to go to somebody who was going to be objective about this. That is not something that needs to be done when you're talking about medical treatment. I think our medical primary care providers do have bias and don't need to be purely objective. The requirement that Dr. Gurton be purely objective arises out of the fact that this was in purposes of this criminal investigation, not for treatment or diagnosis.
Thank you, counsel. Does anyone have any follow-up questions for Mr. Waldo? The case will be submitted. Thank you both.